I'm Anthony Kovic, and you're watching LeaderCast. Today I'm with Tom Hogan of the Hogan Law Firm here at the Brooksville offices boardroom, and we're going to discuss wills and the importance of a will and why everyone should really have that will, or else they'll be, because technically everyone has a will, because when the courts get to your issue, they're going to decide everything. So it's better that you have your version, correct?
That's correct. What you don't want to do is you do not want to die what they call intestate, and that means you die without a will. And that's when the courts will decide how your assets are divvied out. And there's a set prescription in the statutes that says that your assets go first, for example, to your wife. If you have no wife, then to your children. If you have no children, nieces, nephews, and things like that. Of course, if you have debts, your creditors get your assets first. So there are any number of reasons that you can already see that you do not want to die intestate.
So what does it take to organize a will? Really, money goes to here, the house goes to there. A few pages?
It's normally a simple will is about 2 or 3 pages under Florida law. The trick to a will is that it has to be properly authenticated. In other words, under Florida law, your will has to be witnessed and notarized. Has to be witnessed by 2 witnesses. So what a lot of people make the mistake of is that either they bring their will from another state with them, thinking that it's going to be valid in Florida when it's not, or they think they can draft their own will from some form that they get off of the internet, but they don't have it properly authenticated, and it's, again, it doesn't hold up, and you end up dying intestate when you think you had a will. So it's best to spend a few dollars to give you that peace of mind, knowing that you have a properly drafted will. There are any number of attorneys here in Hernando County that can draft a good will, so there's no reason not to have one.
Now, should it be specifically a will attorney that is fluid in drafting wills compared to a real estate attorney that may be fluid in drafting documents for real estate transactions?
Yes, as I always say, and I've said on other shows, the law is so diverse these days that no one lawyer can keep up and keep current with every area of the law. And you never know when the law of probate is going to change. And if your will does not match the most recent case law or the most recent change by the legislature, then you are not going to be taking either advantage of the law, or your will could be thrown out. You also need, it's also very, very important that you discuss your will with your accountant, because the amount of money that you can pass on without estate tax fluctuates from year to year depending on what mood Congress is in. On the year that Mr. Steinbrenner passed away, estate tax was 0.
Okay.
So I don't know if he did that on purpose, but
yeah, he probably waited to the last minute. I thought there was something about that there was the will with Steinbrenner.
Yes.
So you definitely want to pass away on a 0 estate tax year.
So your accountant should play an important role in your estate planning.
Now, what if, estate planning is one part of it. You have your will, divvying up of assets. Then you have your medical side. Like how, let's say, what are some of the medical things?
You have a living will, is a term you're looking for.
Yes.
A living will designates a power of attorney to another person to make a decision as to whether extraordinary efforts should be made to keep you alive. If you are critically ill and there's no chance of your recovery, the hospital has no choice but to keep you on ventilators and keep your body functioning, even though there may be no brain function. So you want to have a living will that gives your surrogate the right to give the hospital permission to turn off those extraordinary life-saving efforts if there's no hope. Now, these are all things that people want to avoid talking about because it forces us to face our own mortality. But I try to look at it as the business side of passing away. And you do not want to leave your heirs or your family in a bad situation. I can tell you one quick story that
Go ahead, tell us the story.
A judge, as you know, I've got lots of stories, but a judge here in Hernando County was holding a probate hearing where there was no will, and the family had divided up into two factions, and he was holding the hearing in his conference room, much like this conference room, and one faction of the family was on this side of the table, the other faction on the other side of the table, and even though the judge felt that the room was nice and cool, everybody at the table was perspiring heavily. And so he called a recess, and they all left his chambers, and he asked his bailiff, why are they sweating like this? And the bailiff said, well, they're all wearing bulletproof vests, because come to find out they had had a shootout previously. That's how contentious probate can be. And it's a sad fact that we've seen many family units break down after the passing of a patriarch or matriarch of the family. And people have strong disagreements about how assets should be divided. You know, oh, I took better care of Mama than you did, or I drove Daddy to the doctor every time he needed to go for years and years. I should get this or that, or I helped work in the orange grove, you didn't, so I should get the orange grove. And it's just creates a giant quagmire if you don't take care of those issues in your will, or I suggest a trust document before you pass away. You are preserving the family unit that can go on for decades after you're gone if you take care of those issues while you're still here.
Because the arguments don't necessarily have to be about money. It could be, any item, whether it could be a doll.
It could be.
Where that is their favorite doll. No, that was mine. I want that one. They want that one. Who knows what it could be? And
it's often something that you cannot imagine would be that important. I saw a probate battle over a Lazy Boy recliner. That was Dad's Lazy Boy recliner. I want it. No, I want it. And it was ended up a judge had to decide on who got the recliner, which cost, now that recliner's worth, I don't know, $10,000. I mean, it's ridiculous. So a will is a very cheap investment. A trust is an even better investment. And there are a number of attorneys in this county that are competent to do that. We have them right here in our firm, but I'm not selling it. I'm not selling the firm necessarily for that, because you're kind enough to have me on your show again, which I greatly enjoy, by the way.
We enjoy having you on.
But I'm saying get a will and or a trust. Have a consultation with a qualified lawyer. It'll save your family a lot of grief.
Now, in the trust, a trust is basically a corporation. Is that correct?
A trust is not really a corporation. You're thinking of
like a real estate trust?
A real estate trust.
Oh, okay, so
this what I'm talking about is there are two types that deal with probate of your estate. One of them is a revocable trust, and the second one is an irrevocable trust. So let me talk about the revocable trust first. And that's what most people choose to have. And I'll explain why. A revocable trust is an instrument that sets out your wishes as to how you want your estate assets dispersed upon your death. And you, as if it was you, if Anthony came to see me, or came to see Mrs. Hogan in the law firm,
exactly,
who's the expert, she would tell you that you would be the trustee of your revocable trust. So you can amend your trust at any time. Life goes on as normal. You don't really feel any difference. But what you have to do is you have to transfer all of your assets into your revocable trust. So now your checking account, for example, will say Anthony Revocable Trust,
okay,
instead of just Anthony. And your car titles, your boat title, the stocks that you own in your 401k or wherever you own stock.
Everything has to go into that entity.
Your company. Everything goes into that entity if you do it right. And then you also have a will on the side that says, if I have forgotten to put anything in my trust, it now goes into my trust. Everything I leave by will, everything I forgot to put in my trust, to my trust.
So it's basically the will just tells everything to go into the trust. And the trust is... So how is the trust managed?
Well, let me say that's called a pour-over will. So if you go to an attorney, make sure you get a pour-over will into your trust. The trust is managed like this. You would designate in your trust your successor trustee. My name is Tom Hogan. I founded the Hogan Law Firm more than 30 years ago. And what we really enjoy doing here is getting to know our clients and trying to help you solve your issues, your problem, your transaction. We enjoy that. We're lucky that we can make a living doing that, but the main source of our satisfaction over the years is the friends that we've made through the practice of law and the people that we've helped. Our main source of business is the referrals from our former clients. So give us a try, give us a call. We can represent you in many areas of law, whether it's family, domestic law, divorce law. We do a lot of transactional law, meaning wills, trust, estates, real estate transactions. We handle civil litigation. We handle employment law, representing employers primarily. One of our attorneys is very well qualified in that area. We represent several governmental entities, so we have experience in that area and can represent you with other governmental entities where we don't have a conflict. So if you'd like to get to know us, if you'd like to see if we're the attorneys for your issue, give us a call at our phone number, 799-8423. We have two locations, one in Brooksville, just down the street from the courthouse, 20 South Broad Street, and one in Spring Hill at the corner of Mariner and Spring Hill Drive. Look forward to getting to know you. Thank you. And most often, the husband and wife designate each other. You also have to designate a second successor trustee because you may die with your wife in a common disaster. So it would be, your brother, your oldest child, whatever the case may be. When you pass away, your revocable trust that you could amend at any time during your life now becomes irrevocable. And the trustee now is in charge of that trust. And you can set forth in that trust as much detail or as little detail as you want. But most people will put in their trust, especially if they have minor children, they will say that I want my assets to go first to the health and education of my children. Next, I want, if there are assets in excess of that, I want the remainder of my assets to go to my children, liquid assets, but not until they attain the age of, people choose different ages. I mean, we've had people that have chosen 55.
Yeah, I mean, at least they had money all the way up to 55, right?
Well, the idea being that that money is protected. It can't be reached in a divorce. It can't be reached by creditors of the child. Let's say the child goes through a bad marriage.
Student loan.
Well, student loans, or has a bad business transaction and has to file bankruptcy, or like I said, goes through a bad marriage. Whatever the case may be, that the idea of setting the disbursement into the final disbursement out that long to age 55 is so that it's there for the child's retirement.
Now, can it be organized where a percentage of the disbursement goes out once a year, let's say?
Absolutely. You can do it almost any way that you want to. We have people say, well, by the age 25, they should know what they're doing. I didn't know what I was doing at 25, but
still don't.
Still don't.
Still don't know what I'm doing now.
Yeah. My granddaughter recently told me I was acted like a teenager, so I took it as a compliment. But anyway,
that's a good thing.
Yeah. But the idea of a revocable trust that converts to irrevocable, handled by your trusted trustee, is that your wishes will be carried out for the benefit and for the good of whoever you want to.
So what happens if the trustee himself disappears off of the scene?
You have
by either death or no longer wants to manage it after you're no longer able to, once it goes into irrevocable.
Well, I'll give you a perfect example of that, and that's me. I had a good friend who, in the late 1990s, when we were both young, virile men,
yes,
asked me to be the trustee of his successor trustee.
Yes.
I said, sure, I'll do it for you. Not really thinking it through, and then he passed away. And I inherited a large company up in the Panhandle. I didn't, when I say inherited, it became my responsibility. I had
the trust man, but you are the trustee, so you have to manage it.
I had to manage that company, 100 people plus. And so I was commuting back and forth to the Panhandle 7 hours each way.
I guess.
And, there was no good flights at that time. I flew some, but,
no trains, right?
No trains. But finally, one of the children became old enough to be the successor trustee, and I had gotten the company in shape. In fact, made record profits one year, but it was a struggle. So think carefully before you agree to be someone's trustee. But what you do in a trust document is, first, normally people name their spouse, and I've already told you of the problem with dying in a common disaster. Then they will name either a brother, sister, friend, oldest child.
Like in your situation where the trust entity that you needed to manage was out of your space. So if someone was a trustee in another state, they would have to manage it from far away.
They would have to either manage it or hire a manager, but they'd still be responsible. Mm-hmm. And they still have the responsibility to the beneficiaries of the trust.
So can you designate, let's say, a lawyer or accountant or anyone it could be anyone, or
yes.
Just...
And normally what people do is they'll, like I said, you'll have spouse, brother, sister, friend, accountant, lawyer, but ultimately, if all of those people pass away because your birthday cake explodes or something and they're all at the party, people will name a bank. Like Bank of America does trust work, for example.
Oh, okay. So you can... Now, does the trustee get paid to manage this whole thing? Because I'm sure in the case of running somebody's company, there might be a lot of time and effort that took place. Can you add that to the mix, or is it automatically... How does that work?
You can add it, you can specify it in the trust, or the statute allows for it. No one expects you to act as trustee without some compensation. It has to be within reason.
Yeah, I mean, it's not like, your travel time, expenses, whatever. I mean, if you were running the company from there, somebody would have to do it.
But you can't, as trustee, you can't come in and give yourself such a huge paycheck that you bankrupt the company.
Yeah. I mean, that's...
So you have to be reasonable.
Better to specify, right?
It's better to specify, and it's better to understand what the bank is going to charge if you elect to have a bank serve as trustee, because some banks charge a lot of money to be trustee. Yeah. They charge like 5% of the value of the trust per year.
Let's never mind all the bounced checks that they will get the fees from. Right?
That's right.
Like, what happened here? Why are you bouncing all these checks? Oh, well, we're making extra fees.
Sometimes banks can be expensive, so you need to explore that. But also your investment companies, Raymond James, I think, will do trust work. Schwab, Merrill Lynch,
Okay, so you could technically designate a entity like
yes.
Schwab or whatever, and rather than someone that may not be up to the task. So
right.
If you have no siblings or someone that's up to the task, you can designate one of these corporate entities. Now, do you have to designate them in advance, where they sign and all that stuff? How does that work?
You designate them in advance, and they sign, agreeing to accept the responsibility, and then they have to agree that if they're bought out, for example, they will. If whoever buys out that bank doesn't supply trust services, and they have to help you find or help your beneficiaries find a trust company.
So what if, let's say, you wanted to make sure your cat lived in the condo, and taken care of by butlers, etc., etc. We've heard these kind of stories. Is that plausible?
It's plausible, it's legal, and we've done it. We've done it for cats, we've done it for dogs. I don't always think that would be the best use of someone's money, someone who dies without children, without offspring, without family. I would, to me, maybe the Red Cross or the Salvation Army might be a better choice, but or maybe Leader Cast could use some new equipment.
Yeah, need some new equipment. So.
But seriously,
can I designate a website for them to send them?
We could start it.
Yes.
But seriously, we have done estate plans where dogs and/or cats or other pets have been designated as the recipients and to be cared for in a certain way until they pass away, and then the residual of the estate would go to a charity.
Yeah, so the barbecue pit just went kicked on, right?
Who knew?
Yeah, so now other things such as, living will, like hospital care, what other parts of a will that people should be aware of that they need to implement?
Well, they need to have a living will, which is separate from their probate will. They need to have a trust, in my opinion, because if you have a will, you're still going to have to go through probate, because a judge is going to have to rule on whether or not that will is valid before it can be enforced. And if there's going to be a battle in the family, it'll occur if you die intestate without a will, which we've been over, but it might occur if you die with a will, because we have seen this many times, and we have attorneys here that do probate litigation, and there's a lot of it in this community because you look at our demographic, and there's a lot of elderly people that live here. People retire here, and so they pass away here, so probate is here. And a lot of times people will come to see us when they're very, very ill and they want to change their will. And so we make sure that they're competent, make sure that they understand what they're doing, and we have witnesses there that will testify that they knew what they were doing. They'll change their will. Now, Mama passes away, and Junior thinks he's getting the El Dorado.
Exactly, and who's this person? And
come to find out that Mama left it to the gardener because he
took care of the house.
Took care of her in the last year of her life, and Junior never came down from New York to see her. And so, Junior flies down for the funeral and says, where are the keys to the El Dorado? And the gardener's driving away.
It's pulling the gardening truck.
Right, it's pulling the gardener's trailer. So
exactly.
And then there's a dispute. Then there's a lawsuit. Mama wasn't competent at the time she changed her will. So it's important that we like for people who change their wills in the last stages of their life to publish that fact to the prior beneficiaries, so there's not allegations of fraud, allegations that Mama was taken advantage of, allegations of forgery.
Now, when you say publish, we're talking about putting it in the newspaper or sending the recipients in the will a copy of the will?
Well, I'm talking about sending the recipients a copy, or at least letting the lawyer send a letter to the normal beneficiaries, being the children of a man or a woman, that your mother or your father has retained us to rewrite their will. If you'd like a copy, please, let us know. We'll send it to you, email it to you, whatever.
Yes. Now, if you have a trust, which all the assets of the will of the person goes into the trust continues on.
The trust continues on. It just, like I said, it converts from revocable to irrevocable. There is no probate. You do not go to court. The trustee just picks up right where you left off and continues on with your instructions. And your instructions in a simple trust would say, I want you to
sell the company, phase out this, sell this, give this to this person, do this to that person, whatever,
exactly.
Until the trust is zeroed out. Is that what happens?
You can do that. There are all kinds of instruments that would be that could be used in a trust, and that's why we need to get Debbie on your show. She can go into a lot more depth, but you could have generation skipping trust. In other words, you could have a trust and you could take the corpus or the body of your assets, the liquid assets. You could instruct your trustee to sell your business, liquidate all of your tangible assets, put all those into your Merrill Lynch account or wherever your savings are,
yes.
And take that corpus and invest it, so much in, 10% in the Dow Jones, 30% in municipal bonds, that sort of thing. Don't leave a penny to my children, but instead I want to leave it to my grandchildren when they obtain the age of 30. Or I want to leave 20% of my estate to my grandchildren when they reach age 35, and then I want to leave 20% to their children, and then to their on and on it goes.
Now, when it comes to the trust itself, is that a corporate document, meaning you said it's not like a real estate trust where it's a corporation. Is it just, how is the trust managed?
It's a trust. A trust is managed by the trustee. You can set up, during your lifetime, you can establish an irrevocable trust. That way...
I mean, is that something like when you file a corporation with the state of Florida, you get a certificate? What is the trust entity like? What is it?
You don't file it with anybody.
Oh, okay.
Okay, you don't have to file with the state of Florida. But if you establish an irrevocable trust during your lifetime, and there are reasons to do it, but if you do it, your accountant will have to file for what's called an EIN number.
Oh, okay. So you do got to file with that with the federal government.
And you have to pay taxes on the income that the trust generates. Now, if you have a smart trustee, there will be very little taxable income because the stock portfolio will continue to reinvest.
Well, I mean, that's after you die. You
No.
deal with the taxes, even while you're running the trust.
Yes, you're not running the trust anymore if it's an irrevocable trust.
I mean, it's a revocable trust.
A revocable trust, you goes still on your tax return. You still pay taxes. It's just like normal. Your Social Security number is your tax ID number.
You still have to have an EIN number.
No.
No.
Your Social Security number is your tax number if you have a revocable trust.
Yeah, okay, so you would just say on all your documents it's Anthony Hovig Trust?
Anthony Kovac Revocable Trust is established on July 25th, 2019. But you can put that in short abbreviations. Basically, all it needs to say is Anthony Kovac Revocable Trust.
You would just, let's say, set up your bank accounts that way. Everything's set up like that.
Your bank account, your deeds to your house, to your
Okay.
and there's a let me put a footnote on that. There is an argument about whether homestead is available to a revocable trust or not. I believe that it is, but that's a gray area. But you would put it on your deed to your business properties, your boat, your cars, your stock certificates, everything that has an indice of ownership, you want to put in the name of your revocable trust.
So after you pass away, then it has to be set up moved into a corporation.
Then it moves to an irrevocable trust.
Yeah.
Then it has to, your accountant will apply for your EIN number, and then your trustee takes over running the trust.
Yeah,
Now, you could set up a board of trustees. You could set up, my two brothers and my sister as equal co-trustees. That would look more like a corporation, but it's not a corporation. It is a separate instrument.
So anyone could set that up. It's not a really complex.
It's not complex, but I don't advise you to try to do it yourself. There are some things that you need to have an attorney work on with you. It has to be, again, properly witnessed, and you have to make sure that you properly fund your trust. One of the biggest and saddest mistakes that we see is people will come hire us. They'll pay us to draft a complicated trust document that, maybe a portion of it skips a generation, maybe a portion of it is set aside for a terminally ill child. There's all kind of complicated things that can go on in a trust, and we draft all this complicated document for them, but then they don't fund it. They don't put all of their assets into it, and so we have to go through probate anyway. Earlier when I talked about the pour over will, what I was talking about there are only assets that don't have a written indice of ownership, only assets that aren't titled, like cars, trucks, boats, buildings, other tangible assets. I'm talking about your clothes, your jewelry, your collection of baseball cards.
So anything that doesn't have a title of
goes into your pour-over will.
Ah, okay, so that's what that means. So it's not like if you had $500 in cash laying around, it's not a title, so it's considered.
Your bank account has to be in your trust, but cash that's in your dresser drawer does not. Any cash that is found, in my dresser, on my person, in my home, goes to my pour-over will, and the pour-over will puts that into the trust, and the trust disperses it to your instructions that are in the trust.
And anything in the mattress goes in the pour-over will.
That's right. Anything in the mattress goes in the pour-over will.
And so anything else on trusts and wills that we should continue covering?
Let me go back real quick to irrevocable trust and why you might want that. If you are involved in a risky business, let's say that you own a fleet of rock trucks, and you can imagine, I don't have to spell it out for you, you can imagine that a disaster may happen that might exceed your insurance, and might involve that a plaintiff may find some way to pierce the corporate veil, which we can talk about on another broadcast. But you may want to put assets into an irrevocable trust, which is protected from your creditors. So that way, your critically ill child, for example, your critically ill wife, for example, you know that she or he will be cared for even after you pass away, even if your business gets totally wiped out because of some catastrophe.
So that's an important factor there. There are plans in these wills and trusts and everything that we've talked about that have a purpose, and whether a disaster takes place, a corporate disaster, it's the hurricane comes in and takes out all your stuff, but you still owe the debt.
Correct.
Even if your insurance pays for everything, but that could be 6 months from now, the business is gone.
Gone.
We talk about this when it comes to like corporate prepping. If you leave your fleet in the same parking lot compared to dispersing them and making sure that your employees take your fleet and keep it out of harm's way if possible. So instead of losing 50 trucks, you lose maybe 3.
Right.
And because, yes, insurance will cover the trucks, but they may not cover the stuff in it. That could be more expensive than the truck. And
your loss may exceed the value of your insurance policy.
Yeah. But more importantly, your business doesn't recover.
You're unable to service your customers while you're retooling.
And while you're waiting for insurance companies to come out and process your claims, etc. And the next company is, listen, if you're a plumber, and guess what? If you can't show up on that 24-hour emergency, somebody else will.
Yes.
So I'm Anthony Kovic with Tom Hogan with the Hogan Law Firm. Thank you, Tom, for
always a pleasure
spending some time with us, talking about important legal matters that can be useful just by knowing what to do and finding, a local lawyer, preferably, like the Tom Hogan, and the Hogan Law Firm for all of these kind of services. But the important thing is to understand what we're talking about and learn that these are options that you should consider when dealing with your wills and trusts and managing your financial entities, right?
Right. Very simple things that you should do to take care of your family, you won't be the one to pay the price if you pass away and leave a mess for your family, but you don't want to do that.
Exactly. So I'm Anthony Kovic with LeaderCast, and we'll see you on the next episode.
Thank you.